Hello there, my name's Louis MacWilliam. I'm an immigration solicitor and head of immigration at Truth Legal Solicitors. Today we're going to talk in some detail about how to make a successful spouse or partner visa application. So this is the visa which will allow you to join or to continue living with your partner or spouse. And this is the visa which, particularly in the last 7 years or so, has become particularly tricky. So we'll look at the legal requirements for making a spouse visa, and then we'll go through my 9-step guide about how to prepare the application. So that's really about the procedure. I've then got a section on what to do if your visa's been refused, so whether to appeal the decision or to make a new application. And then we'll finish off with 5 most common mistakes that I encounter. So this podcast is actually based on a detailed legal guide, which is on the Truth Legal website. So you're welcome to cross-reference that or to use that as a written guide. So no need to take notes. So I've tried to condense quite a few years of knowledge and experience into this guide, into this podcast. However, I do have to say that if you are in the middle of preparing your spouse or partner visa application, do check what the latest requirements are, okay? And you might think I would say this, but it is generally advisable now to get a legal advisor, an immigration solicitor, to assist you with the application or to at least provide you with some initial advice to make sure you're on the right path. So before I dive into the legal side of stuff, well, who's this guide for? It's for anyone who meets the definition of a partner. So that can be a spouse, a civil partner, an unmarried partner, or a fiancé. Now, just bear in mind, if it's an unmarried partner, if you are trying to make the application as an unmarried partner, then you will have to have cohabited with your sponsor for at least 2 years prior to making the application. As I said, I'm going to look at the legal requirements and then the procedural requirements. It's really important that you do understand both. So if you get the legal requirements bit wrong, then your application is probably going to get refused. If you get the procedural, if you don't really understand the procedural side of stuff, you might not be refused, but you're going to have an extremely stressful time when you actually get around to submitting your application, providing supporting documents and such like. So yeah, it's really important that you understand both the law and the procedure. One immediate consideration you'll have is whether you should be making your application from outside the UK or from within the UK. Now, if you're already outside of the UK, then it's fairly straightforward. You have to apply from outside the UK. However, if you're already in the UK looking to make a spouse visa application, then it's not necessarily quite so straightforward. If you have a valid visa, then you can switch from your existing visa category into the spouse visa category. However, you can't do that if you're here as a visitor. So visitors are specifically excluded from applying within country and have to leave the UK. Bear in mind, if you're an American, Canadian, Australian, New Zealand citizen or some other what they call non-visa national, you might be here without a visa because you can travel visa-free. However, in that situation, you're technically still here as a visitor. So don't think that you can switch into the spouse category. You will have to make an application from abroad. Last thing about this is that if you don't have an immigration status, if you're here unlawfully, perhaps you've overstayed your visa, it is possible to switch into the spouse category from within the UK, but it's very tricky. You'll have to show that there are insurmountable obstacles to you and your partner, or if there's a child, to the child living together abroad, and this is interpreted strictly. If you are going to, quote, do the right thing and go home to apply for your spouse visa, just be careful that there are no general grounds of refusal or suitability issues which will be held against you, because that can lead to you being refused entry to the UK. And I'll look at these in a bit more detail shortly. And if you have these grounds of refusal applied to you, then you're effectively locked out of the UK for a set period of time. Okay, so I'll now deal with the key legal requirements for making a spouse visa application. So from now on, I'm going to refer to these types of applications as a spouse visa application, but actually I am also referring to unmarried partners, fiancés as well, but just for ease of reference, I'll refer to spouse visas from now on. Okay, so the first set of requirements I want to look at are the suitability requirements and general grounds of refusal. So these are the requirements which will relate to your prior conduct, so what you've done in the past. And if you fail on these grounds, then your application will either be automatically refused or it will normally be refused. So the second one means it's a discretionary ground of refusal. So there are loads of different types of general grounds of refusal and suitability requirements. I'm not going to go through all of these now. Some of them are fairly obscure. However, the majority of these grounds of refusal, or the ones which are most commonly used, relate to previous criminal offending, immigration offending, the use of deception or making false representations, that's a really big one, or if you owe money to the Home Office or the NHS. It's worth just pointing out that if you have previously overstayed, okay, if that's the only potential ground of refusal in play, then that in itself cannot form the basis of a refusal if you're making a spouse visa application. It can do in many other applications, but not in a spouse visa application. However, just be careful, because if you've committed the offence of overstaying but have what they call an additional aggravating circumstance, okay, then this could be a discretionary ground of refusal. So, for example, if you've previously absconded, you've been on reporting restrictions and you've not complied, or you've not complied with bail conditions, that could be an aggravating factor which, combined with overstaying, could form a general ground of refusal. So that's an overview of the suitability and general grounds of refusal. The next key requirement is the relationship requirement. I'm going to look at some particular elements of the relationship requirements in more detail in a second. But some of the kind of more routine requirements are: you must be over 18 years old. The relationship must not be in what they call the prohibited degree of relationship. So there's a restriction on blood relatives marrying. You must have met in person. Any previous relationship must have permanently broken down. And if you're married or in a civil partnership, then it must be a valid marriage or civil partnership. It's just sometimes people get caught out by religious marriages. So a nikah marriage conducted in the UK is not a legal marriage because the UK doesn't recognise religious marriages of these kind as being legally binding in the UK. However, if that nikah marriage took place in a country which recognises nikah marriages, so most Islamic countries, then that would be recognised for the purposes of UK immigration. Okay, so those requirements are fairly black and white, but some of the less clear, less well-defined requirements include the requirement for your relationship with your sponsor to be, quote, genuine and subsisting, quote. And you'll also have to show that you have an intention to live together permanently in the UK. So there's no mandatory documents which you have to submit to prove these points, but I always see it as really building up a convincing picture by providing as much relevant evidence as you can. You should certainly be giving evidence of how you've been keeping in touch with each other whilst you've been long distance. If you've been visiting each other, okay, so whether that's in the UK or abroad, that's excellent evidence to use in this regard. And if you are married, then you might want to provide some additional detail of the marriage, so it might be a wedding reception. So I'd tend to advise my clients to provide some of the following evidence where it's applicable. So I'd always want evidence of remote contact. So that's emails, Facebook, messages, WhatsApp and such like. Evidence, if there have been any visits, evidence of flights, boarding passes, hotel receipts. Now, if you're a bit light on evidence, you should certainly consider giving a witness statement to explain some background information about the relationship, how the relationship's developed, how you keep in contact, what your plans are for the future. You might also consider evidence from a third party who can attest to the relationship. So this might be another witness statement from a family or friend. Just bear in mind they'll have to provide their ID. And this kind of statement is, if that's all you've got, you might be in a bit of trouble, but it is better than nothing. Just a word of warning on photographs. They are useful, but on their own, they're fairly useless. So you can put in a few photographs to bolster your existing evidence, but don't go overboard, because I think you just upset the decision maker if you send in hundreds of photographs. So the photographs carry limited weight. If you've been living together, then you must provide evidence of cohabitation, and this would be in the form of utility bills, maybe a tenancy agreement in both your names. It can be in joint names or in single names, but at the same address and spread out over the period that you've been cohabiting. Now, if you're applying to extend your leave and you've already had your initial visa, spouse visa, you're applying to extend it, you absolutely must provide evidence of your cohabitation during the currency of your initial spouse visa. And again, you'd have to provide utility bills in each name or in joint names spread out the whole of the visa period. And if you can't provide evidence of cohabitation in these circumstances, then you have to show good reason consistent with a continuing intention to live permanently together in the UK why you can't provide such documents. Okay, so they are the relationship requirements. Now on to the big one. This is the one which catches most people out. It's the financial requirement. There's a reason this catches most people out, and it's not always just because people don't have enough money. It's because it's a very complex area to work out how much you're meant to be earning, and then the evidence you have to provide is very specific, and if you don't provide the exact evidence required, then you can be refused. So I'm going to go through this now. So starting off, well, what is the financial threshold that you're working to? Answer, £18,600. However, if you have additional dependent children, then this figure goes up. It goes up by £3,800 for the first dependent child, and then £2,400 for any dependent child thereafter. Okay? So just to give an example, if you had the spouse had 2 dependent children, this would be £18,600 plus £3,800 plus £2,400, which I believe makes £24,800. So that would be the figure you're working to. Bear in mind that if you have British or EU children, or otherwise what they call settled children, then they are not dependent children. Okay, so they do not increase the threshold you are working to. I'm going to explain how to meet this threshold in a second. If the sponsor is in receipt of certain benefits, so this includes disability living allowance, carers allowance, or personal independence payments, and there's a few other ones. If your sponsor is in receipt of these benefits, then you don't have to meet the 18,600 limit. Okay, the Home Office recognises this is unrealistic, and instead you just have to show that you have adequate maintenance, which is a much lower level. Okay, so how do I meet this threshold? There are actually a number of different income sources which you can rely on to meet the threshold. These include employment, self-employment, savings, property income, maintenance payments, dividends, or other sources of income from investments, stocks and shares, bonds, or trust funds. So there's a bit of a selection there. I'm going to focus on the 2 sources of income which are by far the most common, which is employment income and relying on savings. So first up, employment income. So perhaps the first thing to note here is whose employment income you can rely on. So if you're applying from abroad, you can only rely on the employment income of your UK sponsor. However, if you're applying from within the UK, if you're switching or extending your visa, then you can rely on either the sponsor or the applicant. You can rely on either person's employment income. So regarding employment income, there's slightly different rules depending on whether or not you've been employed by your current employer for at least 6 months. So if you've been employed for at least 6 months, then the Home Office will look at your annual rate of salary. Okay, so if you're paid £20,000 per annum and you've been working at least 6 months, they will look at your annual rate, the 20 grand. So even if you'd only been working for 8 months, for example, so you hadn't actually earned 20 grand, that's okay. If you've been working 6 months, you can still rely on your annual rate of salary. If you've been working for less than 6 months, then different rule applies. The Home Office will look at your actual gross income, your employment income over the previous 12 months. Okay? So just again, using if you're on a salary of 20,000, but you've only been working for 3 months, they will add up those 3 months, however much you got for those 3 months, and that will count towards the financial threshold. I mean, you might have another job covering within that 12-month period that you could also rely on. So there's a couple of things for you to think about. The other major source of income which people rely on is savings. And it's actually the savings is where the really tricky calculations come into this. So first of all, if you just want to rely on savings to meet the financial threshold, so let's say this is just the basic 18,600. And so if you just want to rely on savings, you would have to have £62,000, okay? And there is a calculation behind this. It's not totally plucked out the sky. First of all, you actually discount your first £16,000. I don't know why, but they do. And then any amount over that, they divide by 2.5. And the reason they divide it by 2.5 is because your visa is valid for 2.5 years. So divide it by 2.5, and then if you're in excess of 18,600, you're home and dry. And this is the reason why that all works out at 62,000 if you want to meet the financial threshold purely on savings. However, you can mix savings with other forms of income, including employment income. So if you fall short on your employment income, you might be able to top that up with savings. So in my legal guide, I give this example of if you've been earning £15,000, you're falling short of the financial threshold by 3,600. And to top this up with savings, you'd need to multiply this 3,600 by 2.5 and then add on this £16,000. That would show you how much you need to make up through savings. So in this example, it would be £25,000 would actually be needed to top up a shortfall of 3,600. Totally appreciate this is really not a straightforward area, and I hope I've kind of tried to explain it, but as I'm speaking, I'm realizing that it's not easy to explain in a podcast. But have a look at the legal guide I've written if you want to go through this at a slightly slower pace. When you're applying for your visa, certain documents are what they call specified documents. This means that they are mandatory, and that if you don't provide them, there's a fairly good chance your application will be refused. Okay? And there are unfortunately loads of specified documents. Most of them relate to finances. Okay? So for stuff like bank statements, pay slips, a letter from your employer if applicable, these are all called specified documents, and you have to provide them in the exact format with the exact information required of them. Otherwise, they don't meet the requirements and you can be refused. This is all contained in something called Appendix FM. So that's Foxtrot Mike, Appendix FM, SE, Sierra Echo. You can Google that, or in my legal guide, there's a link that you can follow and it'll tell you what all the specified documents are. Next up is the English language requirement. You're actually exempt from the English language requirement if you're aged 65 or over, or if you're unable to meet the requirement due to a long-standing physical or mental condition. I would just briefly mention that that's not an easy criteria to meet. You'll need strong evidence if you're trying to show you can't meet the requirement due to the long-standing physical or mental condition. You're considered to automatically meet the English language requirement if you are from a country which the Home Office considers to be a majority English-speaking country. And I say what the Home Office considers to be an English majority-speaking country because many countries which I would have presumed to be majority-speaking countries aren't on that list. So do check the list of countries recognised as being majority-speaking. For everyone else, you'll need to satisfy the English requirement either by having a degree taught or researched in English, or you'll need to pass an English language test in speaking and listening in at least level A1 of the Common European Framework Reference, CEFR. Importantly, you really need to make sure that you're doing this English language test at an approved test centre, a Home Office approved test centre. There's a link to the approved test centres in the legal guide, so please have a look at that if you want to check. I hope that helps clarify the legal requirements. Do bear in mind that if you really want to take the stress out of understanding the legal requirements, then you can contact us at Truth Legal, and we can do one of two things. We can take your detailed instructions and provide you with detailed advice orally and in writing on the legal requirements and how you meet them, and we'll also advise you on the process. Or alternatively, you can then also instruct us to prepare the whole application for you. Okay, now for the procedural stuff, and I've developed here a 9-step guide to successfully making your visa application. So a kind of common question that I get from applicants as they're starting out in this whole process is, well, where do I start? So people know there's these various different steps they have to take. It's confusing and it's not clear in which order the various steps need to be taken. So hopefully I'm going to help with this now and go through what I think are the 9 key steps in a kind of sensible order. So the legal requirements are broadly the same whether you're applying from in-country or outside the UK. The procedure is a bit different, so I'm going to have to go through the various steps and then explain how it's done, either for whether you're applying from inside or outside of the UK. So the first step I've got is, step number 1 is check you meet the requirements of the rules. This is really what I've already just covered under the legal requirements, but the first thing you need to do is make sure you meet the eligibility requirements for a spouse visa before you waste a considerable amount of time and potentially quite a bit of money going any further. If you were to instruct Truth Legal, this is where you can use us to provide you with a review on where you stand in relation to the spouse visa application and whether or not you're likely to succeed. If you instruct us, we give you a checklist of documents which you need to go off and gather. If you're doing this yourself, then you should still make a checklist so you're clear on exactly what documents you need to get. One word of caution, most of the financial documents in particular are time sensitive, so you need to provide, I think all the financial evidence must be dated within 28 days of the date of application. So there's no point in getting your financial evidence right at the beginning because people find that, well, a couple of months down the line, it's too old, so you have to get updated evidence. By all means, check that you are going to be able to get this evidence, but you need to understand that some of the evidence, particularly the financial evidence, you will have to get nearer to the time that you actually submit your application. Okay, so that's step 2. Step 3 is, well, get a handle on how long the application is going to take to be decided and consider whether you want to use some kind of priority service. Now, there's different considerations depending on whether you're applying from abroad or from within the UK. If you're applying from abroad, then it can take up to 60 days to get a decision on your spouse visa application, or even longer if the case is considered to be complex. If you're applying from abroad, you can pay for something called priority settlement, and that, as the Home Office put it, puts your application at the front of the queue and should get you a decision within 30 days. However, we do see this, that applications are taken longer than 30 days fairly routinely. The Home Office, by its own admission on the website, will say that it's probably not worth you paying for priority settlement if your case is, quote, not straightforward, quote. And the Home Office has a fairly wide definition of what they consider is not a straightforward case. It's all about previous immigration offending or even just visa refusals. So the examples they give of what might make your case not straightforward includes having your visa refused to any of the following countries: the UK, the USA, Australia, Canada, New Zealand, or a Schengen country, and Schengen includes most of the EU countries. So even if you just had a visa refused from one of those countries, there's probably no point in you using the priority settlement service. If you're applying from within the UK, then a non-complex case can take around 2 months, but you can pay an additional £500 for the priority service. This should get you a decision within 5 working days. Or alternatively, you can buy the super priority service, costs an additional £800, and this is supposed to get you a decision within 24 hours of your biometrics appointment. So consider how long it's going to take and whether you want this priority service. Step 4, complete the draft of the application form. there are different forms to complete whether you're applying from inside or outside of the UK. If you have a look at my legal guide, you will get the links both to the outside the UK application and inside the UK application. Step 4, I've got review your supporting documents and submit the application and choose your appointment. So I've kind of sneaked in a few smaller steps within this step 4. So yes, check you've got all the necessary supporting documents and then submit your application. After you submit your application, you will have to attend a visa processing centre, which differs depending on whether you're applying from outside the UK or from within the UK. But in either case, annoyingly, you won't actually know of the appointment availability until you submit your visa application. One important point to note is that you'll see various references to the date of application. And that's relevant for stuff like financial evidence, which must be dated within 28 days of the date of application. So, question is, well, when's the date of application? Because there seems to be two important dates. There's the date you submit the application online, and then there's the subsequent date when you attend the visa appointment to enrol your biometrics. So which is the date of application? Well, there's an answer to this. It's to be found in the immigration rules, and it's the date that you submit your application online and the date you pay the application and immigration health surcharge fees. That is the date of application. The date of application is not when you attend the visa centre. Step 5 is provide your supporting documents. Now, this could actually be before, during, or after your appointment at the visa application centre. If you're applying from outside the UK, well, to be honest, the system for providing supporting documents is a complete nightmare. There are various different ways of providing your supporting documents, and these vary depending on the visa application centre that you're applying to. So options include uploading your documents, providing your documents on the day of the visa appointment, of the biometrics appointment, or getting your UK sponsor or UK representative to submit your documents in person or by post at a UK visa centre. We would tend to recommend that where possible, you submit your supporting documents through your UK sponsor or UK representative at one of the visa centres in the UK. If you attend one of these UK visa centres, then there's no need for an appointment, you just walk in. However, there is an additional £75 fee to use this service. Bear in mind here I'm talking about visa applications from outside the UK. You'll have to take with you your passport and your document checklist, as well as a copy of all your supporting documents. It is possible to post your documents to a UK address. It's normally possible. Again, this costs an additional £75. It is becoming increasingly possible to upload your documents to the application website. However, this is a very frustrating, time-consuming experience, so I would just say it's not a great option in terms of anxiety levels. You'll normally have a final option of attending the biometric appointment and providing the documents for the staff at the visa centre to scan themselves. We've had terrible experiences with this. We would advise against this option. We've had visa centre staff inappropriately advising on what you should and shouldn't submit and just simply failing to scan all of the documents which are provided. If you're applying from within the UK, then thankfully the process is much easier. All your documents can be uploaded to the UK VCAS website. UK VCAS is the private company which handles the collection of your application and supporting documents, but UK VCAS website works fairly well, so you can upload all your documents prior to your biometrics appointment. You can, if you like, get the UK VCAS staff to upload your documents when you attend the biometric appointment. I don't really see any point in doing this. Better to do it beforehand. Okay, so step 6 is to attend your visa appointment. So whether you're applying from outside or inside of the UK, you'll have to attend the visa centre to enrol your biometrics and potentially provide supporting documents. If you're applying from outside the UK, then you'll have been offered available appointment slots when you submitted your online application. When you attend your appointment, make sure you take with you your original and current passport as well as your document checklist. If you applied for your spouse visa from within the UK, then again you'll have been offered an appointment through the UK VCAS website, and you need to take with you your current valid passport, your appointment confirmation email, and your document checklist. Now, I would actually recommend taking with you a spare copy of your supporting documents, even if you did the document upload in advance, just in case for some reason some of those documents haven't been picked up properly. The UK VCAS staff tend to be quite helpful, so if anything's failed to be uploaded, they will do that for you. Step 7 I've got, well, nervously wait for a decision. Not much I can say about that, unfortunately. You have to play the waiting game. Step number 8, receive your decision. Okay, so if you applied from outside the UK, you should eventually receive your notification that a decision's been made. You'll have to attend the Visa Application Centre to collect your decision and your passport. When you applied, you might have had the option of using the Keep My Passport service. And if you use that service, then the first step is you get a notification saying, give us your passport, you'll give them your passport, and then you'll get another notification telling you that your visa's ready, or a decision has been made, sorry. They don't tell you whether your application's been successful. They just say, a decision has been made, your passport's ready for collection. If you applied from within the UK, then you're normally sent a letter from the Home Office confirming your application's been approved, and then you should be sent your biometric permit by post to your nominated address. Step 9 actually only applies for applications made from outside the UK. If successful, you'll initially be granted a 30-day vignette, like a sticker in your passport. So maybe stating the obvious, just make sure you do enter the UK within those 30 days. When you get to the UK, you'll then collect your biometric residence permit from a nominated post office. I hope you found that 9-step guide useful. I'm going to shortly look at what to do if your visa application is refused. Just before that, please bear in mind that if you do want to take the stress out of the whole process, that Truth Legal will help you with the entire application process. So if you instruct us to help you with the whole application, our work would involve taking detailed instructions from you, whether that's in person or by phone, Skype, WhatsApp, provide you with detailed written advice, including a document checklist. We will advise on and review all supporting documents, set up a shared drive so we can review your documents, set up the online application, ask you to complete a rough draft, which we will review. We will draft detailed representations explaining your background and how precisely you meet the requirements of the rules. We will help you with the submission of the online application. We will help you with the submission of the supporting documents, and we'll advise you on next steps once your visa is granted. Okay, so the next session is, well, help, my visa's been refused, what do I do? Well, if you're still set on coming to the UK, then you really have 2 options. You can either appeal against the refusal in the first tier tribunal in the UK, or you can submit a new improved spouse visa application. If you choose to go down the appeal route, then you'll have 28 days from the date you receive the decision to lodge your appeal. That's if you're outside of the UK. If you applied for your spouse visa from within the UK, then you will have 14 days from the date of the decision to lodge your appeal. But if you're applying from within the UK, if you did apply within the UK, bear in mind it's 14 days from the date of the decision, which will be different from when you received it. So you'll, in practice, have fewer than 14 days to appeal. On occasion, your appeal might be certified as clearly unfounded if you made an application within the UK. This means that you've only been given the right of appeal for when you leave the UK. Okay? In that case, it might be necessary to do something called a judicial review. Now, judicial reviews, you have 3 months from the date of decision to file your judicial review. If you want to learn more about judicial reviews and other ways of challenging Home Office decisions, you can look at our website, which has a section on this. I want to talk now really about the pros and the cons of whether you should appeal or make a new visa application. Generally speaking, my starting point is, well, can we make a new visa application? That would be my preferred option, generally speaking, because it's quicker. Okay, how long it takes to have your appeal varies. It can take up to 9 months to have your appeal heard. It might then take another month to get your decision. It might take another month to actually then get your visa. It's a very slow process if you try and go through the appeal route through the tribunal. It can also be expensive. I mean, you don't have to have legal representation if you go for an appeal, but realistically, you do want it if you can afford it. appeals are time-consuming from an immigration solicitor's point of view, which is reflected in higher costs. So, in a nutshell, appeals tend to be more time-consuming, there's greater delays, and they are more expensive. So if you think you can overcome the point of refusal simply by making a new visa application, that is the preferred option. So this is particularly in the case of if you've failed to provide some key bit of evidence. You have it, you just didn't include it. So maybe you didn't put in any pay slips to show your employment income. A simple omission, or even if your circumstances clearly change, so you weren't earning 18,600, a couple of months later you are. In that situation, you just make a new visa application, don't bother with an appeal. However, sometimes the nature of your visa refusal will really mean that there's a high likelihood that if you make any subsequent visa application, the Home Office is just going to refuse it. Okay, so for example, if the Home Office have doubts about the genuineness of your relationship, if they have allegations against you to do with deception, dishonesty, false representations. In these kind of situations, it's almost like no matter what you do with a new application, you're going to get refused. So for these types of refusals, I would advise that you appeal, okay, because you're never going to win with the Home Office. You'll need a judge to make a reasoned decision and look at all the evidence. The good thing about a judge is, well, they tend to be more reasonable. It's a bit of a general statement, but they will look at the evidence more in the round, as we say. So they won't focus on whether you fail to submit one specific document. They'll look at, well, does this person really meet the spirit of the rules? And I think it's something like half of all appeals are successful. So the decision making is basically more generous in an appeal. And although I'd say it can be more costly going down the appeal route, if the alternatives of you're going to make another visa application that's going to be refused, well, in the long run, it may be cheaper to go down the appeal route. Now, there are particular implications to bear in mind if you've applied from within the UK whilst you had a valid visa, because the chances are that by the time you get refused, your visa might have expired. But provided you apply for your appeal before the deadline, the 14-day deadline, your visa's automatically extended. So there might be tactical reasons why you might want to appeal from within the UK, even if you're not totally convinced you're going to win that appeal. Okay, so the last thing I want to look at now are the top 5 mistakes I see in a spouse visa application. So by far the most common mistake or the most common reason for refusal is a failure to meet the financial requirement. This can often be a particularly infuriating reason for refusal because often it's very obvious that the individual has enough money and clearly in excess of the financial threshold, but they just haven't provided these specified documents. Okay, so making sure you get the financial requirement right is essential. I talk about this earlier in the podcast, or see my guide, legal guide online for more detail about that. Second most common reason is failing to meet the relationship requirement. Again, I talk about the relationship requirement in more detail earlier on, but the big one that gets people is the requirement that the relationship be genuine and subsisting. And this will usually be a failure on the part of the applicant to provide suitable evidence of the relationship, how they've been keeping in contact whilst they've been apart. Also, if you've been cohabiting, the Home Office will really want to see that. And certainly if you're extending your visa, it'll be fatal if you don't provide evidence of cohabitation. Next most common mistake or reason for refusal is failing the English language requirement. So most people know there's a requirement to have a sufficient level of English, but where people fall down is providing an unsuitable qualification or an expired document, or perhaps you've done the test but it's not at a Home Office approved test centre. Next most common mistake is a fairly specific one, but we do see it a lot. It's where someone is applying as an unmarried partner but they've not cohabited yet for 2 years. So the Home Office are very strict about this, so if you fall short of 2 years cohabitation, expect to be refused. And then the fifth most common mistake is failing to show why EX1 or exceptional circumstances apply. So getting quite technical here, but if you don't meet the standard requirements for a spouse visa, you might have to rely on something called EX1 if you're applying from within the UK, or it's exceptional circumstances on human rights grounds if you're applying from outside the UK. These applications are tricky, have exceptionally high rates of refusal, and a well-prepared application will be showing why the applicant, sponsor or child has to be in the UK, and why it would be impossible for them to live outside of the UK. Okay, and that concludes my spouse visa application guide. I really hope you found that useful. Like I say, we have a written legal guide online which you might want to refer to. Please do check the rules, make sure you meet the requirements of the rules of any Home Office guidance before you apply. Double check where you can what the current procedure is. If you would like us to assist you with the application, then obviously we're more than happy to do that. Please do get in contact with us, details on the website. Thank you and best of luck with your visa application.